familiar with Rob, he actually started this program. He started in Missoula, and at that time it was Today in Montana, and then went through some changes and brought over to the Billings area. They changed the name to Voices of Montana, but back in the day, Professor Rob Natelson started the show. Today in Montana. Is that right, Rob? It was called Today in Montana?
That's right.
Very good. Let's start with the United States.
It was the first commercial radio talk show to go statewide in Montana.
That is awesome, and we appreciate you for that. Great idea. Let's take a look at the U.S. Constitution, Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to this Constitution, or on the application of the legislatures of 2/3 of the several states, shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of the Constitution. So what we're talking about today, Rob, is the application of the legislatures of 2/3 of the several states, of course we're talking about Montana, shall call a convention for proposing amendments, which in their case shall be valid. So, U.S. Constitution, Article 5, Rob, that's where we're at, correct?
That's right. And it might help to break this down a bit for listeners. Article 5 is something which I didn't really know a lot about until I started a research project in 2010. I was already teaching constitutional law at the University of Montana Law School, and I had imbibed certain misinformation regarding Article 5, which research projects straightened out for me. But essentially, when the founders met, they knew that they wanted to make the Constitution amendable. They had had some bad experience with state constitutions that could not be amended, or with the Articles of Confederation that could only be amended by a unanimous vote of the states. So they wanted a document that could be amended for several different reasons. One was they recognized they might make mistakes,
sure,
and that amendment process could cure that. In South Carolina, they had a constitution in 1776. They didn't like it. It didn't have an amendment process, and they had to throw it all out 2 years later. So they didn't want that to happen. They also wanted an ability to respond to federal abuses. There was a concern that the federal government might even use its rightful powers in a bad way, or that the Congress might misconstrue its powers, or the courts might misconstrue their powers. And so they wanted an amendment process to deal with that. And then they also were, they were aware that the Industrial Revolution had begun, that there were going to be a lot of changes in technology and so forth. And so they wanted the ability of the American people to change the Constitution without actually cashiering the whole thing. So they set up a system whereby it's difficult to amend but not impossible. Every amendment must be approved by 3/4 of the states. That's the given. It has to be, the word is ratified. It has to be ratified by 3/4 of the states. It's right in the Constitution. There's no escaping that. And it could be done either by state legislatures or by state conventions at the options of Congress, and both methods have been used. But in order for an amendment to even get ratified, even get considered, it's first got to be formally proposed. I mean, Voices of Montana can't float a constitutional amendment out there and immediately expect the states to ratify it. It's got to go through a formal process. And there are two ways of doing that. One is for Congress, 2/3 of each house, to propose the amendment. And the other is the states to effectively propose the amendment through a meeting called a convention for proposing amendments, which is a kind of a diplomatic meeting among the states. And then they propose the amendment, and then, of course, it has to go through the ratification process. So a lot of people believe that because, and I'm one of them, because of the dysfunction of the federal government these days, we need some changes. The amendment process has proven to be a very powerful reform mechanism. If anyone tells you amendments don't make a difference, ask them whether women can vote. Ask them whether we still have slavery, or whether we have the Bill of Rights, or whether presidents can run forever. Amendments can make a huge difference. They're a powerful reform mechanism, and but the difficulty, a practical difficulty we face right now, is we're in a situation that the founders predicted, which was that Congress had become abusive and governed by inertia and special interest, and it will not propose an amendment itself. Under those circumstances, it then becomes the prerogative, in fact, the obligation of the state legislatures to force the calling of a convention, this diplomatic meeting for proposing amendments. And that is what several groups actually are fighting for now as a way of getting reforms into the system. Now, that's a long answer, but I hope that may unpack this very complicated constitutional provision for people.
Very good. Rob Natelson is with us. Rob, this is something that you'll be very familiar with, that back in 1972, Montana tried a con-con. It was good intentions, for sure. 66 Democrats, 34 moderate Republicans were on the team. They threw out the old Montana Constitution and wrote a new one, something that some folks call a green one. And to make a long story short, we haven't been able – Montana has gone from maybe number 12 in average wage near the bottom, number 49. People call us sometimes a welfare state. Do you think that if we were to open up the Constitution that we may harm ourselves more than be positive towards Americans?
Well, John, I agree with you in your more or less in your assessment of the 72 constitutional process. In fact, I've got an article coming out on that. There are several differences involved. Number one difference is that was a constitutional convention. They were expected to examine the entire Constitution. They were expected, in fact, really to rewrite it. And they were given the power to do that. And that was also true of the Federal Constitutional Convention. They were also given the power to re-examine the entire political system, not just the Articles of Confederation, but the whole thing. This is different. This is what we call a convention for proposing amendments. This is more like, a constitutional initiative like you see on the Montana ballot, like, CI 105 or CI 75. It's that kind of targeted system. The Constitution actually does not authorize a constitutional convention. That it authorizes three kinds of conventions, and none of them is a constitutional convention. This one is called by the Constitution a convention for proposing amendments, and that's all it is. The second thing is that the forces involved are different today. In 1972 in Montana, you had a situation where the Anaconda Company had just left the state, leaving a huge political gap, which was filled very quickly by very left-wing interests. Today, on the other hand, the states are overwhelmingly controlled by Republicans. I think a majority of the states actually have trifecta. Even the governor is Republican. And this, by the way, is a state legislative process, so the governor's not involved. And so it becomes it's kind of an opportunity for conservatives to make reforms they know are necessary. If conservatives muff it, if they do not, in fact, go ahead and say pass an amendment requiring the federal government to balance its budget or term limit judges or whatever, you can bet that once the Democrats are in control of the legislatures of the states, they will go ahead and they'll make the changes themselves. So it's an opportunity that more conservative Americans have right now, and I would just hate to see them fritter it away.
Professor Rob Natelson is my guest, heads the Institute's Constitutional Studies Center and its Article 5 Information Center. He's a nationally known constitutional scholar and author, and a book that is out that he's written, available on Amazon, is called The Law of Article 5. People can get that. Now, that's a pretty deep book, correct? This is more for the lawyer or somebody that's really fighting for this?
Yeah, it is actually for lawyers, for lawmakers, and for people involved in the process. There's a long story out there which has been passed down for many years that, well, there's no real Article 5 law, that the Congress can do whatever it wants. That's not true. There are over 50 cases construing Article 5 dating back from 17 98 right up to this year. And there's a great deal of historical practice that the Supreme Court says controls. We know a lot about how this process works. And so what this law does, it collects it together. For those people interested, though, in the Constitution generally and who want a book that's written for the layperson, I have another one which is available on Amazon. It's called The Original Constitution, What It Actually Said and Meant. And in the original Constitution, what it actually said and meant, it does explain in thumbnail sketches, the Article 5 process and how it works.
Right. Rob, hold on just a second. I got to take a break. I got a hard break that's coming up. And so go to Amazon, look for Robert G. Natelson and some of his books if you're interested in this constitutional scholar talk that we're having this morning on Voices of Montana. All right, text us at 781-627-5483. Rob and Terry will be here for the whole hour. So when we come back, more with Professor Natelson, former law professor at UM, Rob Natelson. And, Montanans are still being educated on this whole COS, this whole thing we're talking about, Article 5 and a convention of states. And one of the biggest questions I always hear is that the convention process will be hijacked or it'll be a runaway. Can you explain why that cannot or will not happen?
Well, the runaway story goes back, the idea that it's going to be a runaway goes back to the early part of the 20th century, but it was first publicized by liberal academics and by establishment types like Theodore Sorensen, who was a Kennedy speechwriter. It was first publicized as a way of trying to discourage people from using the Article 5 process, something like telling them the horrible thing is going to happen to them if they dare to vote. And the way the narrative goes like this, it's, the Constitutional Convention was just called to amend the Articles of Confederation, but it ran away, and that's the only precedent we have, and so this one might run away. And I used to believe all that, but what I discovered in my research is that virtually every aspect of that is wrong. The Constitutional Convention was actually called for a broad purpose, not merely to amend the Articles of Confederation. People have got the document that called the convention wrong. There's also a claim that's related to this that the Article 5 Convention or the Convention of States, we don't know how it's composed or how it's going to be made up. Well, it turns out that there's a Supreme Court opinion which tells us that a convention for proposing amendments is a convention of states. And we have had something like 40 conventions of states and conventions of colonies in American history. We know very well how they're run. There were about 20 of them during the colonial era. There were 11 of them between the time the Constitution was ratified and independence. We've had conventions of states in 1814, 1850, 1861. We had two in 1861, 1889, 1922, 1946, and 49, and we had one last year. And so we know very well how they operate, and how they operate is that the state legislatures tell their representatives, who are called commissioners, they limit them. They tell them what they want to do. They're called for a particular purpose. They have to stick with it in their agenda, and they do. I mean, that's just the way it actually, in fact, works. If anybody attended the Convention of States in Phoenix, for example, last year, or the simulated convention held in Williamsburg, Virginia, in 2016, they operate more like legislatures than anything else. It's not like John, it's not like the Democratic or Republican national convention where you got thousands of people screaming. It's more a gathering of anywhere from, a handful up to maybe 200 people deliberating kind of like a legislature on a particular topic. That is just, in fact, how the process has always worked. So there just isn't a historical basis to the runaway fear. It is, as I mentioned, was used to try to prevent conservatives from passing a balanced budget amendment or limiting the Supreme Court. That's how it was first widely used as a way of discouraging people from exercising their constitutional rights.
Rob Natelson is my guest. A couple questions here. A text coming in that says, I agree. Our nation is heading in a dangerous direction, and something must be done to change course. How many years do you think to turn this thing around? How many years?
I don't know. Look, the real risk here is not that a convention is going to do too much. The real risk is that a convention is going to meet and it's not going to do enough, okay? So that's one of the reasons we have to give such strong public support to the process in order to prop these people up so that they pass an amendment or two that really are going to make a difference. If they pass something like a balanced budget amendment, to cite one example, they can put the country on a better course very quickly. Because what a balanced budget amendment will mean is that Congress is going to have to concentrate on its core responsibilities. It's going to have to fund its core responsibilities, and it can't fund all the politically correct nonsense that's damaging the country. That one change, I think, could have a fairly good effect. I think term limits on members of Congress, that might take a little longer to have an effect, but certainly would have a difference within, say, 5 or 6 years. Term limits on the courts, which is one of my favorites. I mean, The founders never expected Supreme Court justices to be sitting up there for 35 years, you know?
Yeah, like a king.
You see, when the Constitution was adopted, the life expectancy was much shorter.
So good point.
If you look at the Supreme Court justices who, say, President Washington and President Adams appointed, they only sat on the court for about 8 years on average. Today, justices are sitting on the court for like 25 years, and they issue these outrageous decisions that throw the whole balance off. Well, the way to cure that is to have this is why the constitutional amendment process was given to us. The way to cure that is to pass a constitutional amendment saying, look, you can be on the court. We want you to be independent, but you're going to get one long term. You're going to be there for 12 years or 14 years or whatever, and then it's back to the private sector guy, back to live under the laws that you helped make. And so that might take a little longer, but I think it would really help to turn the country around. Let me just mention one other thing, if I could, and answer the question.
Yes.
John, when I was teaching at the University of Montana and at the other universities I worked at before that, I learned that a lot of the garbage that comes out of the university and comes into the foundations and the politically correct elite, a lot of that is really funded surreptitiously or without people knowing it by federal grant programs. And the whole climate change scare is fueled by government money. And once you've got fiscal restraints on the federal government, and they have to do what they're supposed to do, fund national defense, fund Social Security, take care of those things, they're not going to have extra money lying around to help screw up society. So sometimes even a good fiscal reform can have effects beyond their immediate apparent effect.
Are we running out of time? I know the Convention of States, it's been around for 5 years and only has 12 of 34 needed state applications. Now, assuming the rate of apps doesn't slow down, it'd take another 10 years. Do we have enough time for this plan?
I'd like to see it move faster, but it's important to have some historical perspective on this. Probably the most successful application campaign in U.S. history, application for a convention, was between 1899 and 1913, and that was actually conducted by progressives. They wanted to move the election of senators out of the legislatures and let the people elect senators directly. And it took them about 14 years. They didn't quite get there were 48 states. They needed 32 to call a convention. They got 30 or 31. The number's disputed. But it did take them about 13 years to do so. So Convention of States is about a third of the way through. I think that process is going to accelerate. And the reason I say that is that when I first started studying this process back at the University of Montana, nobody knew anything about it. I taught wrong information to my students, for which I later had to apologize about it. It was as a result of my research and the research of other scholars that people began to say, hey, look, this is a process we can use to straighten out the mess in Washington, D.C. Elections aren't going to do it. The budget deficit, for example, keeps going up. And so I think as more and more people realize the importance of this, you're going to see an acceleration of the process. Even so, John, I think you're probably talking a good dozen years.
Very good. Got to take a break. Rob Natelson is my guest. Also, Terry Kramer is here, Montana Events Director of the United States Project. We're going to find out what the professor is going to be coming to Montana for and how you can get involved. Stay with us. We've got a lot of stuff to get through, but, you and Coburn, Senator Coburn, were on Levin's Fox News show. I don't know why I can't say Levine, but Mark Levine's Fox News show. I don't know why. It's such an easy – I can never say his name. Anyway, you were on there with Senator Coburn, Fox News show, Life, Liberty, and Levine, talking about what the Convention of States is not. Can you reiterate that and explain what the Convention of States is not compared to what it is? A lot of people don't really understand. Yeah. They kind of meld. I don't know. Go ahead.
Yeah. It's a little hard, some of the stuff is pretty technical, John.
Yeah.
And some of it, frankly, is kind of almost takes legal background to understand. It's
right.
Just kind of the reality.
Right.
It was not me on that show. It was Mark Meckler, who heads the Convention of States Project. Mark Levin has become a supporter of Convention of States. He relied on a lot of my work, and he gave me full credit for it in his book. And Tom Coburn is a former he's a physician, and he's a former U.S. Senator from Oklahoma who came to the conclusion after several terms in the Senate that things were just not going to be changed from the inside, that it would require us to use this process. Let me just say one thing about what it's sort of like. You know how in Montana we use the initiative process to get stuff done that the legislature won't do? I mean, everybody uses it left and right, but it's a well-established part of the rights of Montanans to use the initiative process. This is sort of like the federal initiative process. This is a way of wiring around the swamp, going around a swamp, and getting the changes that are necessary to be made. As to what it's not, and I don't like to focus a whole lot on that because it's kind of a waste of time, but I can tell you it's not a constitutional convention, and it's not a scary process. It's something. It's a process very similar to one that we've used many times in American history in order to propose solutions to problems. I'll give you a good example. This one comes out of 1889. A group of states had a Convention of States in St. Louis in 1889, and my recollection was that Colorado was among them, but Montana was not. And because, of course, Montana was just getting started. But I think the territory of Montana was represented. They were concerned about the fact that there was monopoly pricing in the beef packing industry, that the Chicago beef packers were really sticking it to the farmers and ranchers of the Midwest and the West. And so they got together in a convention. They met for several days. They proposed state legislation and they proposed federal legislation. They left. And as a result, and they adjourned once their proposal was over, and the proposal had no legal effect at all, but it was a proposal. So as a result of it, several states passed legislation to protect farmers and ranchers against the predatory meat packers, and the following year, the Congress passed the first Antitrust Act, the Sherman Antitrust Act, in response to that. That's the kind of thing for which conventions of states have been used throughout American history. The only difference with this one is this one has the power to formally propose a constitutional amendment within the sphere that it's been given. And so if a state adopts, say 34 states adopt the proposal by Convention of States, then the convention will be able to consider term limits on federal officials. It'll be able to consider fiscal restraints on the federal government, including a balanced budget amendment, but maybe other fiscal restraints as well. And also it can consider reductions in the size and scope of the federal government. What it can't consider is it can't consider increases in the power of the federal government. It can't propose changes in the Bill of Rights. It can't propose anything outside that agenda. And that is the way conventions of states have, and before them, conventions of colonies have worked for 300 years.
866-627-5483. Let's go to Inga in West Glacier, Montana. Inga, we don't have much time, so make your point or ask your question, please.
All right. I just love this. I feel like I'm being reborn. I love education. I'm going for the second book, but I'm teaching a lot of people what I hear with you, and I hope I'm doing it right. That's why I listen to you, and I'm all for term limits. Everything this gentleman has said is awesome. Like I said, you're never too old to learn or you're never too young. Thank you, and I'll keep trying. May not get it right, but I'll go over and over it till I do. Thank you, and Merry Christmas to all of you.
Merry Christmas, Inga. Thank you very much. Here's a text. A common piece of misinformation used by the opponents of Convention of States is that the Convention of 1787 exceeded their commissions and therefore could do so again. Can you explain why that simply isn't true?
Sure. But first, I'd like to thank Inga very much for her comments. And second, the thing about the ability to learn. I mean, I know a lot about the Constitution, but I'm always learning more. And I learn all sorts of things from other people that have nothing to do with the Constitution. She's dead on right about being open to lifelong learning. Okay, the claim that the U.S. Constitutional Convention went beyond its powers is basically an old smear that was raised by the anti-federalists, the people who opposed the Constitution. What actually happened was this. In 1786, 5 states met in convention, and they said we're going to need a broader convention. So they recommended that to their states. They recommended to their states that their states call a broad convention, it's called a general convention of all states, to consider changes in the political system. They used the word constitution, but in those days the term constitution meant the political system. So as a result of that, on December 1st of 1786, Virginia called a meeting for Philadelphia. They empowered their own delegates, and they called a meeting for Philadelphia for May of the following year. And they once again said that this convention would have the power to consider all possible changes in the political system. Right after Virginia did that, other states got on board until there were, I think, 8 states on board. But there were some people in the Confederation Congress. They wanted to limit the power of this convention. You can imagine, they didn't want to be abolished. So delegates to Congress from 2 states, Massachusetts and New York, tried to get that convention call trimmed down somewhat, and they did come up with kind of a weak-kneed opinion that the convention should be limited to amending the Articles of Confederation. But Congress it had no legal effect. Congress had no power to affect this. This was being done by the states. And so when the convention actually met, all but 2 of the state delegations had full authority to propose a new constitution, which is what they very rapidly recognized that they had to do. There have been several studies of this whole process. Most recently, Michael Ferris, a very highly respected constitutional lawyer with a long conservative history, wrote an article last year in one of the Harvard journals in which he discusses this whole process and shows that, in fact, the Constitutional Convention did what it was supposed to do. Now, a convention for proposing amendments is a much, much narrower thing. It's more like a constitutional initiative, and they're limited to considering just amendments within the scope of their call. So it's not really a comparable situation, except to say that we've had many conventions of states, and they virtually always honored the limits that have been put upon them, and that our federal constitutional convention was no exception to that.
Terry Kramer is with us. Terry, you've been listening, you've been taking notes, you've been shaking your head. I want to hear from you, Terry. You kind of bring it back to Montana. I was reading some old notes. I don't think the professor is coming to Montana, but there is a lot of things going on, isn't there?
There are. First of all, I want to just add to what Rob was saying there. I will post a link on the Montana COS Facebook site to a PDF file of Mike Ferris's article in the Harvard law thing. It's a fantastic read. I read the whole thing. It's a heavy read, but once you start getting into it, if you're a history buff, you just can't put it down. So I will put that up. Watch for that, say, in the next couple of days or so. And then the other thing I was going to just talk about is that there's two paths for proposing amendments. And John went over that. The Washington, D.C., basically Congress can do it, or the Convention of States. And what really just always amazes me is that our opponents will say that, oh, no, we cannot do the second process because things are going to run away and sky is falling, Chicken Little kind of stuff. Yet the first option is on the launch pad, ready to take off at all times. So what they're really saying is when they look a legislator in the eye and they say, oh, you want to oppose this because we cannot trust you state legislators with the authority and the power to pull this off. And yet they trust the clowns in Washington. And I just shake my head going, if I'm a legislator, what an insult. Look through it. This is gaslighting at its finest. This is not a constitutional convention. This is a convention for proposing amendments. Pure and simple.
All right. Got to take a break. Let's do that. Professor Rob Natelson is my guest. He heads the Institute's Constitutional Studies Center and its Article 5 Information Center. Nationally known constitutional scholar and author whose research into the history and legal meaning of the Constitution has been cited repeatedly at the U.S. Supreme Court and many, many others. All right, we'll be back.
This Article 5 process is not a constitutional convention. Yet every law dictionary I've ever looked at talks about a constitutional convention as a convention for either drafting a new constitution or amending an existing one. And so they're using an alternate definition, which I've never been able to find in any authoritative source. So I'd be interested if they could show us anywhere that there's a definition, authoritative, unbiased definition, that says a constitutional convention is only for drafting a new constitution.
All right, Robert, unfortunately, we're just about out of time. I want Rob Natelson to have a minute to respond. Rob, go ahead.
Well, the Madison quotes are actually taken out of context. Madison was objecting to, and if you read all of his letters, you see this, was holding a convention immediately after we had already held a convention because he wanted to give Congress first crack at drafting a Bill of Rights. Madison actually drafted the final version of Article 5, including the convention. And later on, when the nullification crisis arose in the 1820s, he strongly favored a convention over nullification as the way to deal with federal dysfunction. The other thing is, one of the things that you learn in law school is that law dictionaries are kind of a place to start only with your research, not to finish. That law dictionary definitions are often not authoritative, in fact. The common use of constitutional convention, as the average person uses it, is a convention to write a new constitution. This simply isn't one. We do have a runaway constitutional convention right now. It's called Congress. Congress can propose an amendment any day of the week, or they can do what they currently do, which is to ignore the Constitution. But the amendment process has been shown to be a way of reigning in Congress. It's been shown to be a way of reigning in the courts. It's been used that way in the past quite successfully. And it's under the control of the states. We all grumble about our state legislatures, but I'll tell you, I trust the part-time state legislature a lot more than I trust those guys in Congress to do what's right, especially when those guys in Congress right now are just unconstrained.
All right, Rob. Rob, will you come back next year? Can you come back?
Absolutely, and I want to and Merry Christmas to everybody.
Merry Christmas to you, Rob.
Go to conventionofstates.com, press the button, sign the petition. More importantly, get 10 of your friends to do the same. When you sign the petition, then that sends a letter to your state legislator. You go on the list in their district as a supporter. We deliver those lists to the state legislators. It means something to them.